Hi, I'm Daniel Findling with Findling Law on thedivorceguy.com, and in this webinar, we're going to discuss mediation. If you're involved in a divorce case in Michigan or even a custody or support case, chances are the court's going to order you to attend mediation, one of the most common forms of alternative dispute resolution. Let's get started and learn about mediation in Michigan law. What is mediation? Mediation is a form of alternative dispute resolution. I've served as a mediator. Let me tell you what it's about. A neutral third party helps facilitate a settlement between the parties outside of the courtroom. Simple as that. You sit down and you may have a lawyer that's saying, hey, this is what I think you should do and why. And maybe the other side's lawyer is being unreasonable. The neutral third party will bring everyone together and try to remedy the discrepancies between the two parties. That is, get you to settle. Why mediate? Well, you mediate because you can control the outcome. There's always risks to going to trial. There's only two ways that a case can resolve. Either you decide or the court decides. And in order for you to decide, there has to be an agreement. And mediation is the process by which an agreement is facilitated. You can control cost and you can control the outcome. And you may not have a choice because in most cases, mediation is court-ordered. Mediation is court-ordered for judicial economy purposes. The majority of cases settle, and courts are overwhelmed, so judges try to help nudge clients to settle their case, and they do so by a variety of ways. One way is to order the parties to attend mediation, but mediation isn't always appropriate, especially in circumstances where there's domestic violence. However, there are protections that we can provide clients, such as meeting in separate rooms, so not everyone's necessarily in the same room when we're trying to negotiate and facilitate a settlement. And the mediator can engage in shuttle diplomacy from one room and then go to the other room. Well, this is what they're saying, and this is what they're offering, and why they're offering, and so forth. The mediator's role is to help facilitate communication between the spouses and, in many cases, the attorney. Oftentimes, an attorney might have unreasonable expectations or an understanding of the law, and the mediator's role is to bring that person back down to earth. And the same thing may be true with a client. And just like most things in life, preparation is key. You prepare to mediate by first having an understanding of the nature and the extent of the marital estate. In the divorce context, we have a verified financial information form or discovery. Your attorney may issue a subpoena or ask interrogatories, which are written questions, or take a deposition with the goal of understanding what there is. For example, if your spouse is a business owner and you don't have an understanding of the value of the business, then how can you engage in a meaningful mediation negotiation? You can't, because you'll never know if what's on the table is fair. So your lawyer should help you prepare, and you should attend mediation only when you have a thorough understanding of what there is to divide. And then you rely upon your lawyer for an understanding of Michigan law. That is, what would a judge do? What does the law provide? And if what's being offered is the same or better than what your lawyer thinks you'll get in court, then you settle. And if it's disproportionately worse, then you don't. It's that simple. Mediation is the process by which we bypass the formalities by preparing, having an understanding of what there is to divide, and knowing what Michigan law provides regarding how to divide it. Now, here's an important caution. The majority of cases settle at mediation. However, you should always take pause, because once you reach an agreement, once you place that settlement on the record, sometimes mediators will record it, other times they'll write it down. But once that's done, it's final and it's non-modifiable, with the exception of issues relating to custody and, in some circumstances, spousal support. The agreement that you reach at mediation as to property is final, binding, and non-modifiable. There is no buyer's remorse. So there may be pressure on you to try to settle at mediation. And it may be a good thing. Your lawyer may be giving you the right advice. It may be important to settle. But don't unless you're comfortable and you've had an opportunity to think about what the deal is and if you're satisfied with it, because you're not going to be able to unring the bell. Only in very, very rare circumstances. For example, you were on incapacitating drugs of some sort that prevented you from thinking clearly, or you're deemed mentally incompetent. Rarely ever is a mediation settlement set aside because mediation is final, binding, and non-modifiable. So I'm Daniel Findling of Findling Law on thedivorceguy.com. Mediation is a wonderful tool. I love mediating cases. I've done hundreds, if not thousands of them over the course of my 25 years. I normally don't serve as a mediator. I'm normally an attorney representing a party. However, I have certainly done both. And I really do like it. It really is a wonderful way to resolve cases. Now, not every case can resolve. And when they don't, you have other options, such as going to trial or arbitrating the case, which is a private trial. It'd be my privilege to help you, and I recognize that you may have additional questions or concerns, so I want to invite you to reach out and call me at my office, 248-399-3300, or email me. Let it be our privilege to help you. I'm Daniel Findling with Findling Law, and this is part of the Michigan Divorce Education Series.